Everyone for joining us for the fourth webinar in our CLE series, Key Legal Considerations for Business Reopening and Rebounding. Today's program will focus on compliance considerations and enforcement trends surrounding the CARES Act. My name is Jennifer Beidel. I'm the co-chair of the firm's White Collar and Government Enforcement Practice Group. I'm also a trial lawyer and a former federal prosecutor. I represent organizations and individuals in white collar and criminal defense cases. Our presenters today are going to be Nancy DiPodesta and Natasha Tidwell, who both are also partners in the firm's White Collar and Government Enforcement Practice Groups. Nancy is also the co-chair of the firm's White Collar and Government Enforcement Practice. She focuses her practice on white collar criminal defense and has led teams of in-house lawyers and outside counsel in handling complex litigation and investigative matters. Natasha is a former police officer and former federal prosecutor. With that background, she offers a practical, real-world approach to leading internal investigations for colleges, universities, independent secretary schools, and other entities in matters involving racial discrimination, Title IX, and other federal and state constitutional issues. So before we get to the substance of the presentation today, there are a few housekeeping announcements I need to make. First, you can submit questions through the Q&A tool that appears at the bottom of your screen. I'll be monitoring those questions throughout, and we will do our best to answer them all, either throughout the presentation or at the end, should we have time. If we run out of time, we will follow up individually with you all by email to answer any questions you have. In terms of CLE, today's program has been approved for distance learning CLE credit in Pennsylvania, New Jersey, and Delaware. Applications for CLE credit are also pending in Minnesota and Florida. As a CLE provider, we're required to verify your attendance. So at random points during this webinar, we're going to display and verbally announce 2 numeric reporting codes that you must record and report back to us using the CLE survey link that you received in your webinar reminder earlier today. That's one option for reporting those codes. The other is to record them and include them within the thank you for participating communication to be sent within 48 hours of this program. Within that communication, there will also be a link where you can report the codes. After we receive those, we'll send you your certificate of attendance. Within 48 hours of this program, you'll also receive that thank you for participating email that I just mentioned, which will include links to both the CLE survey and a link to the recording of this webinar. So please know this webinar is being recorded. In terms of a legal disclaimer, note that this webinar does not constitute the provision and receipt of legal advice. It is just information that does not create a lawyer-client relationship and should not be acted on without seeking professional counsel who have been informed of the specific facts. So with that, I'll turn it over to Nancy and Natasha to get to the substance of the presentation.
Thank you, Jen. So thank you everyone for joining us. Before we dive into the economic impact and sort of give you an overview of our presentation today, we obviously need to take a moment to recognize the very real human impact of COVID. We were thinking that less than a month ago, a colleague of ours at the firm gave a similar presentation to this one, obviously not as good as ours will be, and obviously not in front of as smart an audience as ours, but he gave a similar presentation and mentioned the number of infections and deaths here in the US. And at that time, there were roughly 1.3 million cases in this country and less than 80,000 deaths. But as of Sunday, we are over 2 million cases and 115,000 deaths and rising. And so those are sobering numbers indeed. And so now I will now make the awkward transition back to the economic impact of COVID. So here we have the unemployment numbers, the most recent numbers. There was some confusion in classification at the Department of Labor, but by all accounts, the unemployment numbers did improve last month. Whether the numbers dropped from 14.7% or from close to 20% seems to be sort of where the classification issue arises. The good news, I guess, is that we're still short of Great Depression levels, But the bad news or the worst news is that the economic numbers or the unemployment numbers are far worse than they were in October 2009 in the wake of the financial crisis. Either way, despite having added over 2 million jobs last month, there are still roughly 21 million people out of work here in the US. And Nancy will circle back to that a little bit later to talk about one of the collateral consequences of the substantial reduction in the workforce here in the US. Next slide, please. So as lawyers are fond of doing, we have divided today's presentation into buckets. And as litigators, those buckets must fall within an overarching theme. And so we have identified 3 buckets or phases of our presentation: past, present, and future, which didn't seem nearly flashy or original enough for a theme. So we went with the good old reliable Charles Dickens and A Christmas Carol. And so in a moment, Nancy will walk you through the ghosts of Christmas present, DOJ's current enforcement priorities, and the alphabet soup of task forces and law enforcement agencies that have jumped into the fray. We will then enter our time machine, or the Longorian, I think it is, from Back to the Future, and travel to the past to explore what lessons we can glean from DOJ's previous efforts to stimulate the economy or provide relief to people impacted by disaster. And then finally, we will try to read the tea leaves and provide an overview of what conventional and unconventional wisdom states will be the priorities for DOJ and others, as well as the compliance risks for which you should be prepared. So in a non-webinar environment, I'd awkwardly ask you each to raise your hands if this sounded like fun. So I guess one positive takeaway of this sort of webinar environment is that you don't have to endure similar efforts to break the ice, and we can just get right into it. Next slide, please. So the here and now, the ghosts of Christmas present. Next slide. So I promised Nancy that I would handle the math before handing it off to her. So here's the grim reality of the numbers. As of now, the government is prepared to pump about $2 trillion into the economy, mainly through loans, but also with direct payments to individuals. Currently, at least one chamber of Congress is prepared to issue a second round of stimulus money. And whether and to what extent that will happen is unclear at the moment. The not as bad as we thought job numbers from last month may serve to signal that a recovery is in the works. But $2 trillion either way is a lot of money, and it, coupled with the grim economic conditions and the massive unemployment numbers, will create temptation and a need for oversight. So I'll turn it over to Nancy to discuss the potential avalanche of fraud in this environment that's ripe for fraud. Next slide, please.
Thank you, Natasha, and I appreciate you handling the numbers. The numbers, all the numbers that we're hearing are just absolutely staggering. In this culture, in this environment that we're in, the DOJ, the Department of Justice, has come forward and they have issued certain enforcement priorities. On March 16th of this year, the Attorney General issued a memo to all of the U.S. Attorney's offices. And in his words, this pandemic is dangerous enough without wrongdoers seeking to profit from public panic, and this sort of conduct cannot be tolerated. He therefore directed all of the U.S. Attorney's offices to prioritize the detection, the investigation, and the prosecution of all criminal conduct related to the pandemic. Less than a week later, we saw a memo come out from the JAG, or the Deputy Attorney General. In his memo, he identified specific crimes that the DOJ has seen since this pandemic. And he also identified certain categories of offenses. And while some are listed here, those are some of the specific crimes that we've seen. I think more generally, and in terms of categories of what is being seen and what is being investigated and prosecuted, there are the individuals and the businesses that are taking advantage of the crisis to engage in fraudulent or otherwise illegal schemes. So there you see the classic sort of the mail fraud, the wire fraud, the healthcare fraud, computer fraud type cases. We're also seeing the trafficking in counterfeit goods, as well as the sale of fake drugs, as well as fake cures. Another category identified is criminal activity relating to malicious hoaxes or a threat to purposely expose others to COVID-19. Those are more of your sort of terrorism type related cases. Looking at a third category, it's individuals or businesses that are accumulating medical supplies or devices beyond what they reasonably need and for the purpose of selling them in excess of the prevailing market prices. These cases tend to fall under the Defense Production Act. And then a fourth category of what we're seeing that is more likely to impact businesses here is the conspiring to fix prices, whether it be bid ridding or just basically an agreement as to what a price is going to be with respect to COVID-19 materials. So the monopolization or the anti-competitive agreements related to critical materials needed to respond to COVID, those are being prosecuted under or can be pursued under the Sherman Act. Then just on that very same day, there was another memo from Attorney General Barr, and on that day he created a task force dealing with the hoarding and price gouging. Next slide, please. With this emphasis on enforcement stemming from COVID-related crimes, we have seen all sorts of task forces come about. And part of the direction that the Attorney General gave to the U.S. Attorney's offices was work with your state and local authorities. And so this is just a sample, and I will say only a sample of the various task forces that are working together and to collaborate in order to, again, detect, investigate, and prosecute any sort of criminal activity stemming from COVID-19. Next slide, please. So the next two slides are just samples of prosecutions that we've seen in really just a very short time. I'm not going to go through all of them, but I do want to highlight the very first one. It's United States versus Stavely, and it's the first prosecution that we've seen. It's out of the District of Rhode Island, but it's the first prosecution that we've seen stemming from obtaining loans through the Paycheck Protection Program. This case was a rather egregious case in terms of its facts, and it seems like based on the evidence that has been obtained that we've read about in the complaint, it seems that there is indeed very incriminating evidence against the defendants. It is not one of those cases that sort of is in the gray, so to speak. You know, was a certification made in good faith? You know, was there, you know, in reality, necessity for the loan? This is a case where the company actually wasn't a company prior to the CARES Act and didn't really, in fact, have employees, but instead it was a way to just obtain the loan up to, I think, less than $500,000 by representing that it did. If we can move to the next slide, I think what I want to highlight here is that these are all prosecutions that are brought by various U.S. Attorney's Office on different types of charges, but they're all within the last 2 weeks. It just, I think it underscores the point that U.S. Attorney's offices are making COVID-related crime a priority. We see it in a variety of different types. We see the criminal activity playing out in a variety of different ways. And I will also say that these cases, you know, we just talked about the collaboration of agencies, but these cases that have been brought are from various different agencies, either on their own or working together, including the FBI, the IRS, the Small Business Association, the FDIC, TIGTA, the Veterans Affairs Office of Inspector General. And while we haven't listed them here, there have also been several SEC enforcement actions that have been brought. And these also, typically with the SEC cases that we've seen, they generally arise from fraudulent statements related to a potential cure or product that will be critical in terms of treating COVID. But But there are those SEC cases as well. And I should say that the SEC, the CFTC, they are all working together as well to share information and to similarly detect any type of fraud stemming from what it is that we're currently going through. If we could go to the next slide, this is this is just a sample of the types of cases that we're seeing and that were already laid out in the prosecutions that we mentioned above. And I want to highlight here, even though I'll circle back to this later, is in the whistleblower claims. There is all sorts of criminal conduct. I am frequently amazed at how creative people can be when they're coming up with illegal schemes and ways to get money unlawfully. But the other thing, with there's the increased risk of fraud, but a very powerful tool that's out there for the government to recover funds that were obtained fraudulently is, of course, the False Claims Act. And while fraud is on the rise, we also expect that whistleblower claims will likely be on the rise as well. And like I said, we'll circle back to that later. Moving to the next slide, there are questions, of course, regarding, there's certain types of criminal conduct. It's black and white in terms of, has a law been broken? Is there a violation of a statute here? And if so, that's criminal. It could certainly be grayer in other areas. And one particular area that comes to mind is potential PPP fraud for borrowers. And as many of you have already heard and well know, a borrower needs to bear the burden of good faith when certifying necessity for a loan. Obviously, the good faith and necessity is a question that, or are words that can be somewhat subjective in terms of interpretation. So borrowers need to remain aware of the potential enforcement actions in connection with the loans, even when acting in good faith. And the discussion here has also recently shifted a little bit too. It's not just making the certification of necessity when obtaining a loan, but if seeking forgiveness of a loan, there's the same potential for ambiguity. Again, it must be in good faith, but those are areas too where they could potentially creep into was this in good faith? Were there false statements made? Is it truly necessary? And it opens up the door to further investigation. The SBA has provided guidance on this, and as part of the SBA's guidance that they put out, they said that they are less likely to audit a loan that is less than $2 million. Having said that, that is not, on one hand, perhaps that's an opportunity, and others might hear that, and they think that there's this opportunity to go get this loan and no one's going to look at it. The caveat there is perhaps maybe the SBA won't look at it, but it is very possible that some other law enforcement entity, in whatever investigation they might be conducting, they could come across it. So the SBA guidance is not binding. The other thing that we wanted to raise is that there's still the risk for false statements to be made in loan applications that could give rise to a prosecution for bank fraud. So while the SBA guidance certainly reduces the potential of a criminal investigation and prosecution for loans less than $2 million, it certainly does not eliminate the risk to borrowers regarding their good faith certification of necessity. Let's move on to the next slide. Interestingly enough, the SBA in its guidance states that the lenders are entitled to rely upon the good faith certification of a borrower. It seems to suggest that lenders perhaps aren't going to be held criminally accountable. I think that would be the wrong interpretation to take from this. Certainly, lenders cannot turn a blind eye to improper allegations, certifications, And they are expected to do reasonable due diligence. Our best suggestion is continue to follow, for lenders, continue to follow the practices that you're already doing, right? The Bank Secrecy Act, the Know Your Customer policies, those continue to remain in place and should continue to be adhered to, regardless of whether or not this is a PPP loan or not. Let's move to the next slide, and I believe I'm going to turn it back over to Natasha to talk about lessons learned. And maybe we'll do this while I'm waiting for Natasha to come back here. But at this point, with respect to lessons learned, there is a CLE code that Jen mentioned earlier in the presentation. The code here is 101896. It's on the screen. So if you just want to send that back in order to obtain your CLE credit, I would go ahead and do that now.
Thank you, Nancy. Yes, the CLE code. Good job mentioning the CLE code that I was supposed to do. I appreciate it. So welcome to the Ghosts of Christmas Past. Since 2000, if you could go back to the other slide for a moment, just give an overview of where we're headed here. So since 2000, law enforcement has mobilized in ever increasing number and increasingly singular purpose ways to combat fraud in the wake of three sort of named disasters, for lack of a better term. The September 11th attacks, Hurricane Katrina, and the 2008 financial crisis. Next slide, please. So if we begin with the September 11th and Hurricane Katrina, first for September 11th, obviously the federal government's response to the massive loss of life, the creation of the Victim Compensation Fund, nearly $2.5 billion was recovered for victims and families of the 9/11 attacks. And while there was a smattering of state and local prosecution ranging from fraudulent charity schemes to insurance fraud, some mail fraud sort of sprinkled in, there was no coordinated federal law enforcement response. And this lack of coordination led to some depletion of the fund itself and lots of misconduct that was uncharged and monies not recovered. Hurricane Katrina was a slightly different story. So in 2005, DOJ established the kind of, the alphabet soup task forces that I like to call them, that we now see with more regularity. The creatively named Hurricane Katrina Fraud Task Force netted more than 900 prosecutions in its first 3 years. The chair of the task force, my old boss, Matt Friedrich, provided what has become something of a mantra and guiding principle for these kinds of law enforcement initiatives. He said that whenever a natural disaster strikes, there will always be unscrupulous people willing to take advantage of victim assistance and rebuilding efforts. What he didn't say is that the law enforcement machine that responds or sort of looks to root out misconduct or folks taking advantage of the assistance and rebuilding efforts, that law enforcement casts a really wide net in doing this. And so, as we'll see in a moment when I talk a little bit about the 2008 financial crisis response, even where a company complies with the government mandates in connection to tapping into recovery funds. In this case, it would be PPP, but in 2008, it was the TARP funds. Once DOJ or any law enforcement gets a peek under the company's tent, it does not always necessarily limit the scope of its review to just the conduct that brought it in. So it may come in just to review your loan application or what you gave to a particular borrower, but could end up down a road that you did not anticipate. And so we'll talk about some of the compliance things the compliance risks that are posed by this latest crisis, and in addition to the lessons learned from 2008. Next slide. So by 2008, the government had sort of gotten the hang of the task force thing and had come full circle on Matt Friedrich's summary of the human condition, that the temptation for folks to try to take advantage is very real, it exists, and it will happen. So the government put out large sums of money to assist in rebuilding, And sure enough, there was fraud. This time, however, in 2008, the federal government was ready. So TARP, the Troubled Asset Relief Program, that the bailout, as it's come to be called, there was an Inspector General created, or Inspector General position created to oversee and coordinate the response. And its mission was to monitor and investigate financial institution crime and other fraud, waste, and abuse. Next slide, please. And so we can see that SIGTARP, if we go through some of the numbers and what was done in 2008, there were 443 individuals charged, 384 convictions, 302 sent to prison. Just if you note that the 92 number, which is bank borrowers, so if you think about the PPP loan program, the SBA program, these are folks who were prosecuted in 2008. 92 of them were were people who were borrowing money. And so again, this is math, so I'm going to screw it up, but that seems like 92 out of the 384 convicted. I can't do the math. I'll just say it looks like a lot. So the prosecution's total, the recovery total ended up being about $11 billion, which was a sizable return on the government's investment in the Inspector General office and in the coordinated law enforcement response. Next slide. So similarly, you know, it's a deja vu all over again. Thank you, Yogi Berra. The CARES Act creates another special Inspector General, this time for a pandemic recovery. It has the same sort of duties or broad mission, the purpose to promote transparency and conduct and support oversight of covered funds and the coronavirus response. And again, the key words being prevent and detect fraud, waste, and abuse and mismanagement. And so this special Inspector General coordinates with other OIGs, coordinates with federal and state law enforcement agencies, as Nancy touched on in the current, when she talked about the current state of play. These task force have already mobilized. There are various agencies, whether it's HHS or DOJ or the various U.S. Attorney's Office, even state governments are involved in this. So this kind of overarching coordinated response that we saw beginning really with Hurricane Katrina and then continuing in full force in 2008 is now, I think the government thinks that they've gotten the hang of this. And so we can expect the CARES Act fraud prevention, as Nancy pointed out, they've already brought several cases already, and for that to continue. But there are some things that if we look back at the 2008 SIGTARP OIG and the prosecutions brought from that we can, that will hopefully inform how we respond or what we're on the lookout for in the CARES Act context. Next slide, please. And so if past is prologue, there are three sort of areas that were highlighted in 2008 that will probably be things to look out for, to consider whether you've already, if you're a borrower who's already accepted PPP funds, or if you're a lender, or if you've got employees who were, there's been some indication or some smattering of cases brought by people stealing the identities of workers who might have been laid off and filing false unemployment claims. So there's any number of ways that you could be touched by CARES Act, even if you or your company is not necessarily a borrower of PPP funds. So the first thing, enforcement may continue long after COVID is gone. So you would be surprised or not surprised to know that the SIGTARP, the OIG's office that was created in the 2008, in the wake of the 2008 financial crisis, is still ongoing today. And in fact, last year, it recovered nearly $900 million in funds that were in TARP funds. So although the CARES Act contemplates that the OIG is set to dissolve in 2025, that could easily be extended. And so CARES Act, this tells us that CARES Act recipients should expect potential audits an investigation into their use of funds for many years to come. It's not necessarily going to stop in 2025 as currently projected. Then the second point, be prepared for a government-issued request for information within months. CARES Act recipients should be prepared for these. If SIGTARP or the OIG and the financial crisis is any indication, beginning in 2009, in February 2009, the OIG for TARP sent a letter to every institution that had received TARP funds requesting that they provide a narrative explaining their actual or anticipated use of TARP funds, including supporting documentation and a certification from a duly authorized senior executive officer that all information that you've provided was accurate. And so even though on the front end in applying for the funds, there were certain good faith declarations that were made, or the government has indicated that if you're under $2 million, the good faith presumption applies. If the roadmap or the blueprint that was established in 2008 is any indication, the government will be reaching out fairly soon to ask you to provide some more documentation. And then lastly, as I alluded to at the beginning, the government's tentacles may reach beyond sort of the CARES Act and into other aspects of your company. So once you've let the government sort of take a peek under the hood, you could anticipate that they might be taken in different directions. There are a couple notable examples in 2008. The first being PricewaterhouseCoopers was the audit accounting firm for one company that received TARP funds. And so when the government went in to check the documentation, to review the TARP disbursement, it noticed some irregularities in sort of the auditing that PwC had done previously, and ended up bringing a charge that way. So there wasn't necessarily anything wrong or any misconduct in the way that in the company's application and the need and the necessity of TARP funds, but while the government was there, they just happened to notice, oh, by the way, there may be this other issue with your auditing. Similarly, General Motors, the ignition switch defect for which they hadn't issued a recall notice was discovered after GM received an $11 billion bailout from TARP. And so GM ultimately admitted to criminal conduct and paid a $900 million penalty. Again, just, wasn't sort of the hot issue or what brought DOJ or the SIGTARP into GM's orbit, but ended up being a real issue for them down the road. Next slide. And so now we'll turn to the road ahead. I'll hand it back to Nancy. But I'm happy. I think this is, if there are questions, Jen, this might be a time to do that.
There are no questions yet, so continue on, Nancy. But if folks have questions, please send them to the Q&A box.
Thanks, Natasha. Thanks, Jen. Just when I thought that I had mastered Zoom, I'm told that apparently there are some issues with my video. So I will just proceed for right now by audio, and hopefully that works. So moving on to the road ahead, and I love what Natasha just talked about, because it's just fascinating to me that the SIGTARP is still, that they're still working, that they're still going, and here we are 12 years later. And I think, as Natasha said, there will be fallouts for a long time to come, stemming certainly from COVID itself, but also the CARES Act and the different loans that are available. There will be a lot of investigations. There will be litigation. We will be busy for quite some time. Let's move on to the next slide. Let's talk about what the road ahead looks like. And one thing that I had referred to earlier, and we do want to mention, and this is certainly an issue for companies, is that there is right now the intrusion of $2 trillion in the US economy comes with a substantial risk of fraud. And when you couple that with reductions in workforce, a potential decrease in salaries, furloughs, in short, disgruntled employees and former employees who may be coming forward to now report fraud. Certainly the False Claims Act, as an example, empowers individuals to become whistleblowers. And please don't get me wrong, there's some may be very well intended and want to identify fraud or wrongdoing within an organization. And then for others, there is a potential for substantial profit to be gained from any recovery. I will also say that there has been a federal hotline that has been established for the reporting of fraud related to COVID, where people have been encouraged to report suspected fraud schemes. So this is certainly something that is out there and perhaps a potential concern for employers and companies operating in this environment. Let's move on to the next screen. This is just an example of the SEC's whistleblower program. And this is in their 2019 annual report to Congress. So before COVID became the reality that we are currently living with today. But so in 2019, the commission received its second largest number of whistleblower tips. It also awarded approximately $60 million in whistleblower awards to just 8 individuals whose information and cooperation assisted the commission. That number to me is striking, but clearly it gives an incentive for individuals to come forward and report, whether it be to the SEC or the DOJ, or, as we'll talk about in a minute, to bring their own action in the hopes of obtaining a substantial recovery. And just looking at the SEC's whistleblower program as a whole, since the program began, the commission has awarded approximately $387 million to 67 individuals. So there is a great incentive, as I mentioned already, to come forward, report wrongdoing. And unfortunately for companies, that certainly opens up the door to an SEC investigation, a DOJ investigation, or what perhaps an investigation from other enforcement agencies. Let's move to the next slide, please. This is the False Claims Act. And one of the greatest tools that the government has in combating fraud is the False Claims Act. It is an incredibly effective tool. Certainly, we expect to see, and history, as Natasha was talking about, has shown that with an increase in government spending comes an increase in enforcement actions, and the FCA is certainly included in that. So pursuant to the FCA, the government can bring an action seeking treble damages and civil penalties against businesses or individuals who submit materially false claims. And it also allows private plaintiffs, who are referred to as relators, to bring the key TAM actions and, in effect, step in the government's shoes. And there will be plaintiffs' attorneys out there who will be looking to bring these types of cases going forward. So let's move to the next slide, because our job here is not to scare you. We want to caution you and let you know what is out there. But there are also things that you can do in order to protect yourself, your company, from an FCA action or government investigation. Before we move on to that, however, there is another CLE code here, 112790. So this is, I believe, the second of 2 codes that you need to submit back in order to obtain your CLE credit. And while you're doing that, let's just move on to the next slide and talk about what you can do. The goal here is mitigate and minimize your compliance risk. And there are some very practical, I think, some very practical direction that we can provide in this regard. You know, one of the things, particularly with money, you know, if your company or you are going to get money through the through the CARES Act understand the program rules. And that actually sounds simpler than what it is, because the rules and the guidance can be somewhat ambiguous at times. So given that, it is really important in terms of defending an FCA claim that if you as an individual or business received government funds based on a reasonable interpretation of what is an ambiguous requirement, that the government has not provided any contrary official alternative interpretation, then there is no False Claims Act knowledge of falsity as a matter of law. So in other words, make sure, track and understand the legislation enacted in response to COVID-19 that may impose obligations on you or your industry. I think you have to come up with what is both a reasonable interpretation and I would also say defensible interpretation of the rules and the guidance, particularly where they are ambiguous. I cannot emphasize enough the importance of perhaps, in terms of developing reasonable interpretations that can be a defense down the road. It's got to pass the smell test. It has to be credible. It makes sense to seek the advice of counsel in determining what is a reasonable interpretation. And I would also say, document that. Make sure you keep a record of why you did, what you did, and based on what. That can come in handy as well down the road if you are asked, as Natasha was referring to earlier, to provide documentation, to provide responses, to answer questions in response to government inquiries as to how, as to why you did what you did and why that was appropriate. So document your compliance or document why you did what you did, but also to the extent that you have the opportunity to do so, document any communications that you have with the government and its agents regarding whether or not you are within the appropriate bounds of the CARES Act or the loan that you are seeking and obtaining. If the government, there's good case law that says if the government continues to pay you after you bring this information to whatever that information might be to their attention, then it is arguably not material. And that's critical. And again, in defending a False Claims Act case. Another thing that I would say is, we've already talked about keeping good records. Have an effective compliance program. We have talked about this over and over and over again, the need to have an effective compliance program. So, and that has come up in so many different, like in the defense, whether it be the environment that we're in now, whether it be CARES Act, or whether it was, historically FCPA or Medicare fraud or whatever the subject matter that it is, compliance. It is such an effective way of, one, responding to and defending your company or defending your company, but it's also a really effective tool for identifying wrongdoing and then taking subsequent remedial action to root that out. So let's move to the next slide. Let's talk about what a good compliance program looks like. And I want to refer you to the U.S. Department of Justice, the Criminal Division. They, in April of 2017, they provided guidance on what is an effective compliance program. But they updated this guidance just recently in June of 2020. And essentially, they ask, there are three fundamental questions with respect to a good compliance program. Is the program well designed? Is the program applied earnestly and in good faith? And I want to touch upon that because so many times, there can be a compliance program in writing, right? But if it's just in writing and on a shelf somewhere, it's not likely effective. And it certainly isn't going to be the defense that you want it to be, if and when the government comes knocking. The compliance program, it has to have meat, it has to have substance, and it has to be applied. And that is something that prosecutors are going to look at in looking at your company's compliance program. And then, does it work in practice? Is there an opportunity for someone to come forward and make an anonymous complaint of wrongdoing? What happens when you get that complaint? Is it just dismissed as not credible? Is there further inquiry made? Or do you go even further to investigate it? We're not saying that every time that there is a complaint on a hotline that a full-blown investigation is required. There are good reasons many times why that may not be the case, but they cannot be readily dismissed. And at least if it is going to be dismissed, why is it being dismissed? And make sure to document that. Do people know that there's a compliance program? Do they know that they have the opportunity to come forward and report wrongdoing? Is there training? Is there an expectation throughout the company that bad conduct will not be tolerated and there will not be a blind eye to it? Again, it's not about just having a program. It's about having a program that actually works in practice. And these are, this is broken down in great deal in the memo that just was recently put out by the criminal division, the DOJ criminal division. But I would certainly encourage you to look at what is required, what a prosecutor will be looking at, not just at the time of investigation, but at the time of charging with respect to your compliance program, and how it can be a really effective tool in either defending your case or otherwise negotiating with the government in terms of how any investigation of wrongdoing could be resolved. So, as I mentioned, sometimes when a complaint comes in, how it's going to be handled, when very frequently what we see and what we get called upon to do are investigations into alleged wrongdoing. So I'm going to turn it back over to Natasha. So Natasha, that you can talk more about what that looks like.
Actually, Nancy, before you turn it back to Natasha, we do have one question at this point. So for either one of you who wants to address this, the question is essentially, given the good faith certifications required under the CARES Act, does that present any unique liability or other concerns for individual managers, directors, board members, officers of entities that don't typically arise?
It's an interesting question, and I'm not sure that I see anything unique, so to speak. I think that certainly, I think managers, directors, if your company is obtaining any type of funding through CARES, I think you want to know, what are they signing off on as being true and accurate to the best of your knowledge and belief? Are those, if, obviously not every individual is going to review every application that's made, but certainly you want to know that those applications are being done accurately, truthfully, and in good faith. Again, I would say, given the amount that is at issue, if it's less than $2 million, like I said, the SBA is less likely to audit it, but that's not to say that others won't. And I would also say that if it's more than $2 million, yes, I think that there is a greater chance that that is going to be looked at, especially if forgiveness of the loan is being sought. If at any point there's anything that comes to your attention and it doesn't seem right, previously there was the Safe Harbors program. I believe that was over as of May 18th. But I would still say, to the extent that you notice anything that might have been off about an application or inaccurate, first of all, I would seek counsel on that. I would not act without that, and then make a decision as to whether or not it would be appropriate to disclose that.
And I'm just waiting for my video to back on. Thank you. So just to follow up on what Nancy was saying in an answer to the question that was posed, where I see potential risk or where executives probably need to sort of be careful is in the compliance space. So under DOJ's new guidance, as Nancy mentioned, they may be signaling where they might be, where the connection between compliance or where the connection between compliance and the CARES Act can be felt most acutely, or where it sort of intersects. And so in the compliance guidance, they highlight whistleblowers, as Nancy talked about, and also, but whistleblowing in regards to third parties. And so if we are thinking about layoffs or furloughs of employees who may be motivated to file false claims actions, we also have to think about if you're bringing in third parties to take over positions or to do to subcontract out for work that would normally be done by your own employees. If these third parties are not trained, or if the onboarding process is just sort of left, if you give them some guidance at the beginning, but then you never follow up with anything throughout their the lifespan that they're in the company, the new compliance guidance sort of highlights that that's an area of increased risk. So if an executive or a manager, the failure to maintain effective controls within sort of this CARES Act space where either employees are laid off or your anonymous tip line for people to call in with complaints of internal misconduct are not, the controls within that are not to an extent that DOJ views that you've made sort of the best efforts. So that's a potential area where compliance and the CARES Act may potentially intersect, and so I would be mindful of that in sort of in advising your executives and managers and CEOs and what have you. Which leads me sort of this reporting of the anonymous reporting by whistleblowers, or sort of whatever reporting hotline you might have set up within your organization, to the potential implications for internal investigations of COVID-19. And so, because, you know, this strange new normal, right, some of the things to think about is timing, right? One thing is timing. DOJ, it appears at least that they've got priorities, other, you know, that they've stated in the COVID space, but also their ability to conduct in-person reviews or investigations or interviews is limited. And so thinking about sort of what the timing, both for if you're going to conduct these investigations yourself or if you're going to farm them out to outside counsel, is this something that can wait? So you also want to think about the atmospherics of, if you decide to do it now and most of these things are done via Zoom, then, you know, how do you, you know, a lot of the feel for internal investigations or any interviews is about reading the room and sort of having this sort of feel for what the witness is willing to give you, or sort of what they understand or what their body language tells you. And that can be like darn near impossible to gauge in a Zoom environment, in this sort of remote environment. So thinking about what the upjohn warning is going to look like, or sort of how you're going to, you know, establish a rapport with a witness that you're trying to get information from, and trying to do that over video. So if it's something that you need to do now and you can't sort of control it, then fine, but these are some of the things that you should, you know, just to think about before you go into it. Also, considering that we're on the web, you know, a whole host of other issues come into play. Data privacy laws and screenshots, and what can you do in terms of sharing exhibits, and what can't you do? Are you going to, if you've got a witness, I had an investigation of involving witnesses who were in Turkey, and they were, there were documents that they needed to review, but those documents could not leave Turkey because they, you know, for whatever the government information and government secrets laws there prohibit the transfer of documents, whether over the web or in any manner outside of Turkey. So figuring out whether or not you can even show witnesses or they can show you a document that they found. If you're talking to a witness who's overseas and the GDPR would apply if they're in Europe, you know, what can they show you if they just happen to say, oh, I know exactly what you're looking for, I have it right here, and it's like, well, you know, what do you do then? So thinking through those potential issues on the front end before you get in a Zoom environment and figure out that you may have run afoul of data privacy laws. We've all heard about the what's happening with Zoom and Zoom bombs and whatever, all of these, the way in which cybersecurity is sort of lessened in this environment. So that's another thing, depending on the sensitivity of your investigation, you know, whether or not password protection is going to be enough for you and a potential witness who may have sensitive information or information that they, you know, quite frankly, you know, would not, you know, are hesitant to reveal to you anyway. And so now you're asking them to talk about these issues, whether it be, you know, some issue of sexual harassment or other misconduct or similar misconduct, where you're asking them to tell you about that over video with a very real possibility that someone, you know, in their mind, that someone might have hacked into the Zoom call or whatever it is. So those are some of the things to keep in mind. Next slide, please. And then, you know, as I alluded to in the beginning, where the federal government, where it seems to be where they are now, their priorities are elsewhere, but they've also stated that they want to minimize in-person interactions to the extent that they can. And so they may be running through the same list of things that we just talked about in terms of conducting your own internal investigation, you know, whether these investigations will bear fruit or will they be able to nail witnesses down or get what they need in a remote environment. So they're thinking through these same things while you know, it's a strategic call or, you know, something that you should debate internally or certainly deliberate about internally, whether it makes sense to delay both the start of the investigation or delaying your disclosure if you were to find any misconduct. And again, that's sort of a gamble that you have to think about. What's the severity of the conduct? You know, what's how close are you to the statute of limitation running, considering that no grand juries are meeting in person at this time. So these are some things to keep in mind because the compliance piece says that your anonymous reporting, your tip lines need to be sort of up to snuff or will be subject to review under this new compliance guidelines. And so you should think about sort of all of these if you're decide to launch an internal investigation right away. And finally, I will mention with regards to the DOJ, the new compliance guidelines, for those of you who haven't seen it, the FCPA blog put out a version of the new DOJ guidance that essentially track changes the old guidance, so you can see in real time what changes were made or what language was adjusted. So if you want to send an email, our email addresses are within the slide deck. If you want to send an email to one of us, we can send that to you. If you haven't seen it on FCPA blog, we're happy to give you that, because it's really helpful to see what was the priority in terms of compliance back then and what DOJ is highlighting now or forecasting now. Next slide. Jen, any more questions?
Nothing here, unless anybody, now's your time to enter any last burning questions into the box if you have any. Okay, so hearing none, that concludes our webinar for today. Remember to keep an eye out for the thank you email that I mentioned at the beginning, which links to both the materials and the recording, and the CLE survey, which is one of the two options where you can indicate the two codes that you saw. And finally, if you haven't already done so, be sure to register for the next webinar in our weekly series, which is called Restructuring Strategies in Light of COVID-19. That's scheduled for next Wednesday, June 24th at 11 a.m. Thanks so much for participating, and please don't hesitate to reach out to any of the three of us if you have any questions.